Welcome to Books of Our Time, brought to you by the Massachusetts School of Law and the American College of History and Legal Studies. Today we shall discuss a book about a major economic and legal subject, intellectual property. The book is Piracy, the Intellectual Property Wars from Gutenberg to Gates, by Professor Adrian Johns. Professor Johns is a professor of history at the University of Chicago, and he is with me today to discuss his book. And I am Lawrence R. Velvel, the Dean of the Massachusetts School of Law. Adrian, thank you very much for coming from Chicago, a place I grew up but don't get to very much anymore. And whether I grew up or not, that's subject to question also, of course. But perhaps we can begin by having you describe the concepts of intellectual property and piracy. I suppose one could say the twinned concepts of intellectual property and piracy. And what do they mean, and which came first and gave rise to the other, which is somewhat counterintuitive?
It is. Well, first, thanks for having me on the program. So, intellectual property. The name is actually simple, and in conceptual terms, it is fairly simple. It's simply the idea that one can claim for usually limited times ownership in some respect of intellectual creations, whether those creations be textual works or pieces of music or designs or perhaps machines or even processes or algorithms these days. So anything that can be regarded as informational and what one could in principle claim a property for. But it's not a natural thing. It doesn't exist out there independent of legislation or precedent. It's been arrived at but historically through successive statutes and legal cases, and it represents a kind of historically constituted compromise between the interests of creators who want to be able to reap a reward for making creations, and on the other hand the interests of the public and future creators who want to be able to use creations as raw material, if you like, for the next generation of works. Now, piracy is the violation of that. It's the violation of intellectual property in some form. But because intellectual property is such a wide-ranging concept, piracy too is very wide-ranging. So today, just as in the information economy, intellectual property has become something like a kind of structuring principle of a whole global network, piracy too has become something like a signature transgression of the information world. So you only have to open a newspaper or look at a news website and you'll find piracy being invoked pretty much on a daily basis. Now, as for which one came first, as you say, it's counterintuitive. Many of the central elements of intellectual property as it now exists were actually developed in response to claims of piracy. And that includes, for example, copyright itself, one of the central elements of intellectual property. The first statute of copyright was in Great Britain in 1710. It was a result, though, of almost a couple of decades of lobbying by the London publishing industry faced with what it denounced as piratical reprinting. So the piracy came first.
It was a case, as I understand it, where people were complaining about what we would call today being ripped off. And so when they were getting ripped off, they got mad. That became known as piracy, and then you began to get laws to stop the ripping off. That's about what it came down to.
Yes, though ripped off compared to what? I think one has to ask. By what criteria were they being ripped off? Because as I say, any claim of ownership in this kind of domain isn't simply given to us by nature. And in fact, what the London industry was saying was that they had long had a kind of internal system to themselves where one could register titles, and that had suddenly become the subject of large-scale violations.
Is it right that all of this stuff essentially began about the time of the invention of the printing press by Gutenberg?
I think so, yes. Certainly that's a big transition point, because suddenly you have all kinds of new conventions of authorship, for example. You can write a work that is reproduced in 1,000 copies, say, pretty much overnight. And that leads to a new kind of commerce in written products. So piracy, and for that matter, authorial property of one kind or another, really are manifestations of the commerce brought about by print. The only thing to qualify that, though, is to say that patents are actually much older than that. So the paraphernalia for creating and sustaining some kind of property claim in machines is not directly a product of print.
So you're saying that in effect there was something which served the function of patents even before Gutenberg invented the printing press?
Yes, yeah. In northern Italy especially, some of the Italian city-states had what are essentially patent regimes.
Interesting. You know, it's easy to see why people would think that mechanical invention and artistic invention, if I may put it that way, have a certain similarity. They're both products of people's mind. What do but there is also a school of thought, as I understand it, that says in certain respects they are different and shouldn't be treated the same. What are the respects in which they are regarded as different?
Yeah, this is actually a very big motif in the history of intellectual property, the extent to which those two domains are either the same or different. One obvious way of thinking of the difference is to conceive of the phenomenon of independent discovery or independent invention of some device, say. This is something that has in fact happened historically quite frequently. You know, people will come up with devices that look pretty similar or or produce the same result quite independently of each other, but within short periods.
Right.
And usually, of course, this is because you know, they answer needs that exist in the society at that time, and those needs are shared. They're not particular to individuals. On the other hand, it's very hard to think of two authors writing the Divine Comedy, you know, without there being some kind of collusion or theft involved. And that seems to indicate that there's a pretty basic distinction to be drawn.
Right. Under the heading of everything being a matter of degree, there's an old saying that a famous composer was, once somebody commented to a famous composer that he had borrowed a basic line from some other composer, so he was a borrower, and he said something to the effect of, I'm not a borrower, he said, mediocre composers borrow, great composers steal. You know, and you see a certain amount of, when you get things like variations on a theme by Haydn and so forth. But it is certainly, in general, different from the mechanical side, where the world has progressed to a certain point, and now the technology is such that more than one person might come up with what is called parallel invention, I believe. In fact, of course, one of the famous stories is that Alexander Bell and Elisha Gray, came to the patent office on the same day and with the telephone, and Bell beat him by a couple of hours. A lesser-known example is that John Ericsson, the Swede who invented the Monitor, the American ironclad warship of the Civil War, he also invented the screw propeller, and he took it to the patent office just a few days or a week before Richard Gatling, who invented the Gatling gun, the first machine gun, took his version of the screw propeller to the patent office. So these are examples, famous examples of parallel invention, as you were pointing out, you know, of the kind you have pointed out. Maybe you could discuss some of the fields in which, to those of us who are tyros in this business, you know, it is really surprising that intellectual property is playing a dominant role. And in your book, there are 5 in particular that I'm interested in, which I'll just list. One is genetics, one is algorithms, and you'll have to explain what an algorithm is. It's taken me 5 years to get it, you know, to penetrate my mind what an algorithm is. Biotechnology, software, and of all things, fashion. Yeah. So maybe we can start with genetics.
Okay, so there's been the emergence over the last generation, the last 30 years, of an industry of genomics and genetically based medical research, right, which is very closely related to other branches of biotech. This is an industry that is fundamentally informational. It operates by producing discoveries within the informational field of massive genomic databases. So the question is, how do you have a business model for something like that if you don't have informational property in, say, a sequence? which is what these companies produce. And then eventually, hopefully, treatments, therapies, medicines based on that sequence, or tests based on the sequence. The problem, though, is that there's a fairly deep-seated moral suspicion of claims to property at that fundamental level of biological information. You know, in what sense are you claiming something like a property in bits of human nature, say? Right. And it transits over into a question of whether you can have property in living beings, you know, newly manufactured organisms. They're not manufactured de novo, but you know, organisms with, say, genetic traits introduced to them. Right. So oncomouse is a good example. This is a mouse used in cancer research.
Could a layman think of this in simplistic terms as the difference between inventing something that has never existed before and discovering something which does exist in nature?
To a certain extent, yes.
Yeah, okay.
And many of the critics of the extension of intellectual property in genomics, in the genomics industry, would take pretty much that line, that it's overly blurring the distinction between invention and discovery. Because everybody agrees pretty much that you're not supposed to be able to have patents in discoveries. You're not supposed to be able to patent facts. Yeah. So the question is, if you come up with say, some genetic correlation to a particular medical condition, and you put forward a patent, what are you patenting? Are you patenting a discovery that this genetic sequence has that result? Right. Is that your claim? Right. Right. Now, in fact, for technical reasons, it's tended to go through. I think because they are regarded as elements in therapeutic regimes, right? And the regime is something that is not just in nature. But nonetheless, it's a controversial issue, and it's going to get more controversial because of, as I say, the extension of this into the idea of patenting developed life forms. So not just bacteria, but mice and higher forms of mammals. This is, you know, upon us essentially. For a long time, it was dismissed as absurd, but as with the development of genetic engineering techniques, genetically modified organisms, we are at the point where higher organisms can now be regarded as property.
And these are patents on the organism, not on the process for creating the organism?
That's actually slightly unclear, to me at least. And I've spoken to people in genomics who've also said that they at least said to me that they found it unclear too. And I think that to some extent the scope of these patents is you know, it's going to have to be defined by the court system. So there was a period when it looked like it was going to be taken in the hard sense, as it were. So these were going to be actual patents in sequences. But recent rulings, in particular about the breast cancer gene, seem to be kind of rolling back that a little bit. But we'll just have to see it. At the moment, in the air, and it's a matter as much of patent claiming strategy as anything else. So
I'm going to hold off one question until perhaps you can describe the biotechnology aspect these days of intellectual property.
Yeah, that's really what I mean when I talk about it extending into living organisms. So the biotech industry, which has branches in pharmaceuticals but also in big agribusiness, wants to produce organisms based on genetic engineering that will have particular traits. So, for example, you can produce seed for a version of corn that might be resistant to some pesticide or something like that. And the idea is that you can then market this seed as requiring less polluting pesticides and less costly herbicides. But they have to be protected. At least this is the business model. They have to be protected by patents, by intellectual property regimes, because otherwise they will simply kind of permeate out into the agricultural world, and you would only have a one-off inflow of money. You need to get people replanting with your patented seeds year after year. And the controversy about that is it takes several forms. One is that this is developing into a monoculture, which is always going to be risky. You know, some new threat to the ecosystem could arise, and if you have a monoculture, there's less chance that you're going to find resistance. Another is that it intrudes on local cultures. where often there was a custom of either swapping seed in local communities or replanting part of the crop to make next year's crop. That's now a form of piracy for some of these corporations, right? And all of the policing regimes that go with trying to make those changes are resented.
Right.
You know, so people going in to look at what's happening in fields, for example, it intrudes on one's private property. Those are the two big concerns.
You know, there's one point which I neglected to make, and I apologize to the audience for this, but the basis of this business is that we want to encourage creation, both mechanically and artistically, and to do that, it is thought people have to have a right to financially benefit from the fruits of their creation. And so that's why patent regimes arose, that's why copyright regimes arose, and it gives you the right. If you're the person who patented something, who is called the patentee, not the patenteur, I don't know why, but if you are the patentee or the owner of the copyright, you have a right to exclude everybody else from using it. And so you get the sole benefit of using it, and it is thought that the patent system gave rise to such things as the Reaper. McCormick made a fortune from the Reaper, and of course the Gatling gun and various agricultural implements in the 1850s, you know, and et cetera, et cetera. Now, that's what's at stake here with this biotechnological and genomic stuff, that the person who first came up with something like the seed corn, whatever that wondrous stuff that ended famines in India, by way of example, they should benefit economically. Now, but that in itself gives rise to all kinds of problems, and so my question, which we'll get into, but my question is this: why don't we have compulsory licensing so that the person who invents or creates something ab initio, the first person, rather than being able to exclude other people who might be able to improve or might be able to produce it more cheaply, simply gets a compulsory royalty from whoever else uses the patented or copyrighted object?
This is a big question, and in fact it's one that's been asked maybe over the last 200 years repeatedly in various intellectual property contexts. And in fact, in the UK and in Europe and other parts of the world, compulsory licensing systems have actually been introduced into legislation. So the UK, for example, had a limited compulsory licensing regime in copyright for part of the early 20th century. And the reason why it went away was to harmonise with the Berne Treaty, the International Convention on Copyright, which doesn't have such a system.
It does not have compulsory licensing?
Berne doesn't. No.
Berne does not,
No.
okay.
There is a provision in the WIPO, World Trade Organization rules, for invoking compulsory licensing in pharmaceuticals if you are a country facing some kind of medical emergency and you need to get an affordable supply of a certain medicine that's under patent protection, and you can't do a deal with the patent owner. So yes, it is possible to do it under that system. So it's something that's come up repeatedly. And the debate over it is interesting because it doesn't fall out on, as it were, conventional political lines. So there's a strong tradition within laissez-faire economics of thinking that compulsory licensing is a good thing, would be a good thing. You can go back and find allies, for example, of Friedrich Hayek in the 1940s would argue this. On the other hand, it also has a certain, as it were, liberal in the American sense appeal, because it's anti-monopolist, it's against big industry, and it seems to free up the little guy to do things.
Yeah. Now, it strikes me that it's a matter of great import. That's a bad double entendre, as it turns out. A great import in the United States, because our prices for a lot of drugs, and Medicare is paying for a lot of them, and older people are dependent upon them, are very high. And these things are produced much more cheaply in Brazil, Mexico, India, and they can import them here. They could bring them here or to Canada and then here much more cheaply than you can buy them here. And so there's been this vast outcry by the manufacturers against permitting that. And the manufacturers, without compulsory licensing, are free to do that, to you know, police it, stop it, do anything they want, try and get Congress to outlaw it. Well, this is a very serious and ever greater problem, isn't it?
Yes, the pharmaceutical industry is, of course, very worried about it, like you say. They tend to be staunchly opposed to compulsory licensing wherever it's proposed around the world, pretty much for this kind of reason. Yeah. They see in it an almost existential threat to their business models and their model of how research is paid for. Yeah. Yeah. Now, one has to say that the question of pricing of drugs within the US is a complex issue that I don't think is quite, it's dependent on the issue of patenting, but I don't think it's quite reducible to that, because it also has to do with the insurance industry and the fact that so many of the drugs are bought through insurance systems and that whole kind of quasi-cartel arrangement. Yeah. We could reduce, I think, drug prices in this country substantially without doing anything to the patent system by changing the market, by having something like a single payer system. That's a different question. Right. But it's just to say that while the link between patenting and pricing in this country is real, it's not the only thing that's going on there, I think.
And yet, from the standpoint of, for example, Hayek and his school of thought, and the laissez-faire school of thought, if you had compulsory licensing, you were alluding to this, you would avoid government regulation by letting the market cause the reduction in prices, and at least in theory, without any diminution in the quality of the product. So that this is very much a conservative point of view.
Yes, it can be put that way. There's an honorable tradition among conservative economic thinkers that would hold that. Yeah. And it's an interesting point of view because it decouples restriction from reward. It says you can reward innovators, inventors, developers, researchers, and so on, without having to constrain to quite such an extent the circulation of public or goods to the public, right? Yeah. The relation of that question to the relation of quality control is interesting too. Yeah. Because once you have something like a compulsory licensing system, presumably you would cut back on out-and-out piracy, because people wouldn't have to pirate things so much. Yeah. And that would mean that you'd be bringing the alternative manufacturing centers under a regulatory regime. Right. And that too would be one of its real advantages, especially for pharmaceuticals outside the US.
Yeah. Two things come out of what you just said. One, just the other day in the paper, Glaxo paid $700 million in fines for bringing into the United States an inferior product. Now, this is one of the world's great pharmaceutical companies. And there's nothing pirated about this. This was all on the up and up. The only problem being the stuff was no good. So, I don't know what you exactly make out of that, but it's a fact, or a factoid. The other thing is that there seems to be a widespread feeling, and I'm wondering the extent to which you share in it or don't share in it, that one of the reasons we need compulsory licensing or regulation or something is that the profits of the pharmaceutical industry, due to their prices, are way out of hand. And of course, that presumes, you pointed out at lunch that who knows what it costs to bring a drug to market. The estimates range from 200 million to 800 million. But for those who favor compulsory licensing or regulation, they're in effect taking a position that these quote, alleged costs, which may or may not be merely alleged, are just way out of hand.
They are to some extent. They're also asserting that the costs are actually lower than they're sometimes claimed to be. And we do know that for much of the pharmaceutical industry, the biggest cost they actually admit to is marketing. It's not research. Yes. And the other point is that as the industry has agglomerated through takeovers and the like, it's become not exactly a monoculture, but a much less diverse culture. And I think one of the kind of implications of something like a compulsory licensing regime would be that research creativity would be diversified, that it wouldn't be just concentrated in a relatively small number of very large-scale interests. And there's a certain empirical warrant for hoping for something like that, in the sense that several of the big pharmaceutical corporations are facing a crisis because they don't have radically new medicines in the pipeline. Right. They're doing Me Too drugs, incremental improvements of things that already exist, but a dismaying proportion of them don't have big things that are going to come through and are going to be the cash cows for them for the next generation. Right. So there's that issue, which again is not in a determinative sense caused by the patenting situation, but the patenting situation is a big factor in it.
It used to be. I mean, one of the things that I learned from your book, which I really appreciated learning, was that the same arguments and almost the same facts have often been repeated in this field for 500 years. So there's nothing new under the sun. And one of the things that is relevant to this, although it is a latter-day development since perhaps the Manhattan Project, is the whole argument about the Garrett inventor, in other words, a small person, versus the Pfizers of the world, or the government, ARPA and that kind of thing, which are Bell Labs in its heyday, which are gigantic invention machines. And I wonder whether the pendulum is swinging back from what I will call big science or big research to the what has been termed the Garrett inventor, because of what has happened in the computer field, where people, in their basements and in their garages have been creating these amazing devices, plus amazing software. Yeah. So is that causing a kind of intellectual swing back, in your opinion?
To a certain extent, yes, I think so. It does, though, depend on the domain. So it's easier to do that kind of thing if you're in a field like software, where the capital costs that you need are not so huge. It's much harder if you're going to do it in some kind of big industrial enterprise where you need massive costs and regulatory frameworks and that kind of thing. However, it should be said that one of the interesting developments in the last few years has been that with the development of what's called garage biotechnology, because it's now the case that you can set up a very simple kind of biotech operation for roughly the same, allowing for inflation, that it costs to set up a garage software company in, say, 1980, 1975. So at the time when the home computer was developed, it was about the same kind of ballpark cost, which is a very interesting issue. And there are now places in the US and Australia and Europe where garage biotechnology is really taking off. And what's interesting about it is that it often it forms into communities that are rather like the early hobby computer communities, with virtues of sharing. They want to be open with each other. They think of themselves as kind of entrepreneurial, but not commercial, not intellectual property related, exploring communities.
Right. It always fascinates me that after the Garrett inventor, and we got the Manhattan Project type of idea, all of a sudden there's a swing back, at least in part. And as they say, who would have thunk it? Because we all came to believe that you had to have a huge research facility. But technology improved to such an extent, and the computer fundamentally, that now, some guy in a garage can imitate what goes on in the real world with the right software. And you just never, when you tell me that now people can do this in the biotechnology field, I'm just floored. I'm just floored. But it shows that this happened, by the way, in my own field of law, because for a while people were saying the world belongs to the big firms. This is back in the 60s and the 70s, because only they have the facilities and money to do all this research and get all this information. Then you get computers and bang, some guy presses a button and he's got it in his garage, got the same stuff. So it's really kind of curious as to the way the world has swung back because of technological advancement. Maybe you can discuss two other things. Why is intellectual property important in, of all things, the fashion industry?
Yeah, the fashion industry, especially haute couture designers, have been pushing Congress to pass a copyright law that would extend that principle to matters of high clothing design. So, you know, a particular cut of a dress or something like that. And the assertion is that they're currently suffering from a knockoff culture, where high design appears on the streets, on the catwalks in New York or Milan. It's then imitated by high street supermarket designers, and then in fact it's a kind of hierarchy. It's then imitated below that by knockoff street vendors. So they want to have protection along the lines of the protection that's awarded to, you know, the music industry or movies or book publishing. It's easy to see the problems with this, because where do you decide that as it were, the edges of a design are?
Yeah.
At what point, what is it that makes a particular cut actually distinctive and original, when it's really quite a small matter of aesthetics compared to the cut of last year?
Yeah.
That's one thing. So it's going to involve a lot of, as it were, judgment calls, one would think. But the other thing is that within the history of economic thought about intellectual property, there is, again, a kind of tradition in thinking that the fashion industry is a great example of how an industry can thrive without strong intellectual property protections because of market segmentation. So you do have these high haute couture fashion houses, and you have the high street imitators, and you have street vendors, but they all exist in a certain kind of harmony. It's not that the Milan houses go out of business because you know, high street supermarkets imitate their styles. That's never happened.
I'm going to come back. We've got to go to break. I'm going to come back to that, because whether you're talking about the fashion industry or you're talking about musical scores in the 1890s and the early 1900s, or computers, or almost anything, you get a certain question involved here, and it's the same question for centuries. It goes back to the 1500s, I gather, of economic stratification. And that's, you know, on the one hand, we keep talking about, well, what is an invention, and has somebody really come up with something new? And on the other hand, you know, one might almost say, well, who cares, to the extent that whatever the inventor is doing precludes the ordinary human being from participating in this advance. And that's been a subject since what, 1650, 1700? Yeah. Something like that. All right, we'll get into that when we come back. Stay with us. We'll be right back for more on the question of intellectual property.
Massachusetts School of Law. Legal education that is practical, accessible, affordable, and enjoyable. Offering flexible day and evening classes, full or part-time studies, where candidates are assessed not on the LSAT, but their academic and other accomplishments, providing more professional skills training than any other law school in New England. Massachusetts School of Law. Visit us at mslaw.edu, training students to become successful lawyers and advocates, not just legal scholars.
At the new American College of History and Legal Study in Salem, New Hampshire, you can finish your bachelor's degree affordably and get on the fast track to law school. We teach American history, and you'll receive a rigorous education at a very low cost. The small day and evening classes allow you to interact closely with the distinguished faculty. At the American College of History and Legal Studies, professors don't lecture. Through the discussion method of teaching, you'll be engaged in the issues raised in class. You'll learn to be a critical thinker, a better writer, and a polished public speaker. And you'll be able to compete with anybody in today's competitive marketplace. You can also get on the fast track to law school. Qualified students gain early admission into the Massachusetts School of Law. The new American College of History and Legal Studies offers the junior and senior years of undergraduate education. To finish your bachelor's degree, with the opportunity to start your law degree early, call or visit today.
Welcome back. So as we were saying before the break, Adrian, it has been, there's been a constant strain in the intellectual property debate for hundreds of years that says pirates are making available to the ordinary bloke, as they would say in England, right? To the ordinary bloke in the street, fashions, music, books, and you name it, that otherwise would be precluded because the governing model of economic thought in the capitalistic West is make all the money you can from your invention. And if you can make more by selling it only to the very wealthy and only they can therefore participate, well then that's so be it. And a lot of people say, that's not good. And in fact, and maybe in discussing this, you would address this point. About a month ago, it was reported in the papers that a German scholar said that one of the reasons Germany turned from an agrarian nation into the world's third leading industrial power in the 19th century. 1800, it's purely agrarian. 1900, it's the third leading industrial power in the world after the United States and Britain, is because it had no copyright law from 1800 to 1840. So people, you know, quote, pirated, and stuff got read willy-nilly all over the country, and people began, you know, because they had access to it, and people began to use all these modern ideas. And the next thing you have the Kaiser starting World War I. You know? So it's not all to the good, but that's the theory. So maybe you could address some of these points.
First to the market segmentation idea, that even without things like formal laws of intellectual property that would constrain or would allow a patentee or copyright holder to constrain, you have different circulations of creative products to different groups, and these can exist in parallel, as it were. And this has been something that's been pointed out repeatedly in the history of this phenomenon. So by the late 19th century, for example, in the British music industry, there was a company set up called the People's Music Publishing Company that was essentially pirating sheet music by the millions of copies, sending them out through railway lines to Britain. And the leader of this, a man who called himself the King of the Pirates, showed up in Parliament to defend the practice. And he argued that there should be a model which is actually like the railway industry, where you have first-class carriages, second-class carriages, third-class carriages.
Yeah.
And they all get you to the same point at the end, but they do it in different styles. So with music, you might have very elaborate editions with things like variora and commentaries and things like that, which would be expensive. And you'd also have very basic editions that would just give you the notes and nothing else, which would be very cheap. And if you had that, he said, there would be no music piracy, because the output of the publishers would actually match the class segmentation that exists out there in the country. Yeah. And that's an argument that's been brought out repeatedly. The fashion industry is a great parallel example to it. Now, as far as the German case goes, I have a certain sympathy for that argument. It is true that through German unification in the mid-19th century, 1870, 1871 is when it was really achieved, there wasn't a single harmonious copyright or patent regime across what were many different German states. On the other hand, there were other countries that also didn't have patent systems. Switzerland is a great example. The Netherlands actually came close to abolishing it at one point. Britain came very close to abolishing its patent system in the 19th century. There was a very radical campaign against patenting throughout Europe at that point.
Yeah.
And the other thing is that the Germany's had an absence of intellectual property for all of history up to 1800. It's not as though it just came in at 1800. Yeah. So I think that the most that could be said is that when the Industrial Revolution kicked in the Germanys, the absence of an intellectual property regime didn't hold it back. And we certainly, the other thing to say is that we also know of major German engineering figures, Siemens, Bessemer, who came to the UK in order to take advantage of the patent system, and gave testimony to the British Parliament that a major incentive drawing engineers into the country was that they could patent things here. And the Americans thought that about the US system too. That
today, Americans complain mightily that our technology is being ripped off. I don't want to define ripped off, but it is being used by people who aren't paying for it at China, and that you have industrial espionage going on, and of course in Brazil and India with the medicines, they're using the formulae that have been developed by American companies. And we in the United States, I think, tend to lose sight of the fact that we started our industrial revolution by ripping off Britain, did we not?
No, that's absolutely true. The first thing about that, about the initial fear that we have that the United States intellectual wealth is being ripped off, as you put it, in China. It's an interesting thing to try to figure out the economic impact of that. It turns out to be incredibly difficult. There's a very compelling report issued by President Obama's intellectual property enforcement chief about a year ago that went into these numbers that are produced by things like the Business Software Alliance about global software piracy. And it turns out there's pretty much no identifiable social scientific basis for any of the numbers that circulate. Now, that's not to say that the numbers are intrinsically false. It's to say that they're uncertain. And we need some kind of methodology to figure out what the economic impact of these practices really are.
Yeah.
Okay, that's the one thing. But as far as America's historic relation in, say, the early Republic through Jacksonian period to Europe, yes, you're absolutely right. There were systematic efforts to appropriate skills, machines, techniques, people even. You know, individual artisans and engineers were tempted over. And in fact, the British passed a law, had a law that which they reinforced, making it illegal for skilled people to emigrate to the United States.
Yes. They
so
had to be smuggled out.
They had to be smuggled out.
Yeah.
So this was quite a kind of definite, sustained, systematic, programmatic enterprise.
Yeah.
No, absolutely. And it worked to the extent that by 1840s, 1850s, America had industrial plants that were the equal of those in Manchester and Glasgow.
Yeah. The way the textile industry began in the United States, and it began just 10 miles from where we're sitting in Lowell, Massachusetts, which was the beginning of the American Industrial Revolution, when I think it was Francis Lowell went over to England and toured the textile mills. And apparently he must have had a photographic memory, because he came back and he set up the machinery here based on what he had observed over there. And then they smuggled out certain foremen who, as you said, it was illegal for those people to emigrate because they carried the secrets in their head. So we wanted them to come over here and run the machinery. And you know, I just read a book. This is really fascinating by way of comparison. When World War I came along and then World War II, and the African-American community in the South had been, de facto peasants for a couple of centuries, American heavy industry from the North would send people down to recruit workers from the South. And the South, if they found out that somebody was there doing that, they'd run them out on a rail, because they didn't want their captive, inexpensive labor force, which was being held in peonage de facto. They didn't want them escaping to the North to work at what was called Fords, you know, in the steel mills and so on. So there's similar things that have been going on all the time, and now we're involved in a very similar kind of problem. We're involved in similar problems with China and so forth. You say in the book, apropos of all this, that maybe you talk about the intellectual property industry and the fact that it has become perhaps overweeningly powerful. What is the intellectual property industry?
There are two things that might be described that way. The first is just the combination of big media, big pharmaceutical corporations, all of the major institutions that base their businesses on things that can be characterized as information, which these days is more or less everything, actually. One aspect of that is that they're increasingly recognizing that they sit on vast archives of information that can be rendered into profit. So you'll increasingly find that corporations will be charging for access to things that they've done in the past. You know, the newspaper industry is very, very big on this. You know, suddenly monetizing their vast back holdings.
Oh yes, yes.
It means that this is a small part of the world maybe, but it means that those of us who are researchers on the 20th century are suddenly finding it's incredibly expensive to do even quite basic work if you want to reproduce things like images from the past.
Yes.
Very, very expensive. It's crippling, actually.
Yeah.
Now, but that's I don't want to make special pleading for my own world.
Well, but it's true. We find that here when we put in what is called B-roll into these programs, which B-roll is movies or still shots, and sometimes you just can't do it because people want money for stuff, for a photograph that was taken 60 years ago.
Yeah, and that's given the legal structure as it exists, that's a completely rational way for them to behave. You know, it is an easy way to make money out of something that they're sitting on.
Yeah.
But the other industry, which I think you may be referring to, is an industry that's developed precisely for the upholding of intellectual property claims. So it's a policing, interdiction industry, a detection industry. And it's come about through a coalescence of forces from the public police forces, FBI, Customs and Excise, often internal subdivisions of major corporations. So Adobe, DirecTV, companies like this would have bodies within themselves that existed to uphold the intellectual property claims of their major corporations. Trade associations, the RIAA, the MPAA, private detective agencies. Right. So these different groups have come together over the last, say, 30, 40 years to develop a really global, relatively integrated intellectual property defense industry.
Yeah. Discs that one shoves into the, whatever they call that thing under the television set. You know, and the first thing, FBI warning. You know? Oh my God, you know. I gather that a lot of this is opposed by the younger generation under the rubric that information wants to be free, quote unquote. And that is because of the internet and the web, the web, and they think that this is just terrible. That I tend to agree with them, although I also understand the need for people to make money off their efforts. But they think it's just terrible that there can be so much prevention of the spreading of information. And I'll tell you what is particularly interesting to me. You make the point that quite often what the so-called pirates are doing from the days of, quote, pirating music and movies is that they are making available to people great voices, great artists, great creations from the past that the people who own the copyrights are denying because they don't make enough money from it. So therefore you got pirating of records by Lawrence Melchior, you know, and I'm watching, I have to laugh because this is so plebeian, but as somebody who went to school in the Midwest, I keep watching the Big Ten Network and I keep seeing these Big Ten icons. They've got movies from the 1940s and the 1950s. To me, this is a treasure. And until they started putting this on this Big Ten Network, whoever saw any of this? The point is that the younger people are, well, anybody who's been accused of pirating has often said, you know, we're not doing this for the money, and you're not hoarding it for the money either. You're just preventing people from seeing it.
Now, there's a real issue here. I mean, obviously, to some extent, these arguments by those accused of piracy are self-interested, and you know, there's no point in not admitting that. Yeah. But there's also a real issue that in the world of books is often called orphan books. These are books that are in copyright but not in print, so they're unobtainable. But the copyright owners don't see a financial interest in reproducing them, so they effectively become silenced. Yeah. You know, there's no way of getting them without trying to tweak some principle of access out of a byway of copyright law or something like that, or else just being overwhelmingly powerful, as Google is. Yeah. But in the music world, it's the same thing, and this is an argument that goes way back. You refer to people pirating Melchior records, which happened in the 50s. At that point, there were groups of opera enthusiasts and jazz enthusiasts as well, who realized that the recording companies were not going to reissue some of these classic recordings, and decided that it was a public duty that they should do it. And ironically enough, they actually hired the pressing units owned by the big record companies to do the pressings for them. I remember RCA was prosecuting and pressing the record simultaneously, if I remember correctly.
Yeah.
And it wasn't subtle. I mean, the record label was called Jolly Roger.
Yeah,
so
right, right. As a lawyer, I say there's got to be some kind of equitable principle against RCA suing people in those circumstances. One of the complaints that has existed for a long time is fencing off patents so that, you might explain that, and Norbert Wiener came into that, and you might explain who Norbert Wiener was. He's passed away about 10 years ago, I guess, but and that also gets involved with a guy with what is being done by Paul Allen, who was the co-inventor of, with Gates, co-creator of Microsoft. Allen got cancer, so he left, and he took $20 billion with him, and so he's been doing a lot since then. But maybe you can address that whole congeries of things.
This has to do with the perception that patents in the 20th century became a major tool by which big industrial combines could tie themselves together and develop lastingly dominant positions in particular industries. So the great example in the early 20th century is AT&T, which developed a complete monopoly on long-distance telephony in the US, fantastically profitable. By the 30s, AT&T had the largest conglomeration of capital of anybody ever, any group ever created. And it would do this, allegedly, by buying up every patent that was ever filed on anything related to long-distance telephony. So amplifiers, repeaters, any technology that might be the basis for some kind of alternative power center. This culminated in hearings in the Roosevelt administration, which were incredibly embittered about AT&T and the very nature of patenting, whether patenting should be effectively abolished to get rid of this practice. Norbert Wiener was a mathematician at MIT, who, if anybody is responsible for the phrase "information wants to be free," maybe it was him.
Right.
He's
regarded as the father of cybernetics, is he not?
Exactly, cybernetics, yes.
Yeah.
And in the 20s, when he was a relatively young professor at MIT, he developed a filtering technique, a filtering technology for discriminating signal from noise in electronic systems. And this would have been critical for some long-distance telephony. So AT&T bought up the patent, and of course it never did anything with it.
Yeah.
And he actually had another patent, which AT&T also bought up and never did anything with.
Yeah.
And this really kind of seems to have burned into his soul in a certain way. So he spent a large part of the rest of his life, as well as inventing cybernetics, excoriating AT&T and, in fact, the whole patent system at large for creating immoral culture of research, an immoral culture of a knowledge industry. So in the 50s, when he was writing much broader pieces about the nature of information and the emerging information society, he made patenting into the counterpart of, as it were, a jamming device for the signals that might enable a grand future of an information economy. He's really the progenitor, in a certain way, of the ideology of openness in information.
Yeah. The way you describe it, it's really interesting. People who are creative people, they don't do it just for the money. Oh, they're not going to turn down the money, and they want a decent amount of it, and so on and so forth. I'll stipulate to that, as lawyers say. But they really want their work to get out there into the world. And the way you described Wiener, it almost sounds like he was very bitter that his brainchild had been suppressed. And anybody who's creative will understand that.
Yeah, it's an incredibly frustrating thing.
Yeah.
But that gets to another way of talking about these issues, which has been current at least since the 18th century, and I think maybe a lot longer than that, which is to think of them as in some ways the moral counterpart of children. They spring from some particular individual. And in that sense, there's an individuality that goes with one's creative work that maybe is inalienable, and it's certainly inimitable.
Yeah, right.
That puts a different spin on all of these considerations, because in that light, these are not just economic issues at all. They do have issues of a real moral freight.
Yes. And that is something which has been so lost in this society, and I think is only now beginning to intrude its ugly head, so to speak, that people do, in economics, for example, where for so many decades, all that counted to economists was what the rational man would do economically, and it's only in the last, which I always thought was preposterous, but in the last 15 or 20 years, behavioral economics has come to the fore. What is really driving people to do what they're doing? And it's not money alone. Sometimes money doesn't even enter in. Sometimes money is all. But there's a whole congeries of ideas that are relevant. Maybe in the last few minutes, you can describe the Homebrew Club and what it was and who was in it and what came out of it and what Bill Gates's relationship to it was.
This is from the early days of hobby computing in the 70s in essentially Silicon Valley, what is now called Silicon Valley. This was a group of people from various origins who were interested in tinkering with computers as a hobby, which was a thing that was just about affordable by this point. The thing about the Homebrew Club, it's set up in the environs of Stanford, and it became very popular very, very quickly. It met at the Stanford Linear Accelerator building, and it had as it were, an ethos, a sensibility, which was that people were all in it together. They were experimenting, but they were sharing the results of their experiments. And the idea was that if somebody came in with a piece of code, say, then the piece of code could be shared. And the rule was that if you recorded code latterly on cassette tapes, because this was a medium that was just coming in for recording computer software, you could borrow a cassette tape from what became a relatively formal library if you brought it back, and especially if you brought back another cassette tape with your own contribution. So it's a kind of moral economy, if you like. But it's a moral economy where sharing is a prime virtue.
Right.
Now the problem with this...
Which is kind of an internet ethos these days, is it not?
Yeah. The Apple system emerged from this, although slightly departed from it very fast. But Steve Wozniak and Steve Jobs were in the Homebrew Club. And the early prototypes of the Apple I and the Apple II were shown in this Homebrew Club to other participants. It became an issue with Gates and his then very young company, Microsoft, when the Homebrew Club tried to incorporate into its moral economy the code for the basic programming language that had been written for the Altair, which was a manufactured hobby computer. That basic had been written by Microsoft. It was Microsoft's founding product. And so when Gates found out that this code had been essentially appropriated and was circulating through the hobbyists, he wrote an open letter which has become a famous statement in the history of computing, denouncing their practice as theft and arguing essentially that in order to build quality software and to make of this more than just a game, you had to develop real kind of corporate strategies which involved property. And if you'd simply shared, then it was a violation of this. It really was theft to him. That letter, which is called an open letter to hobbyists, has come to mark a parting of the ways, as it were, between the ethos of sharing, openness, research, exploration, and the proprietorial, relatively closed approach that Microsoft still has to this day.
Gates said that in order to have real progress, you had to treat it as serious intellectual property and you can't steal it and so forth. Do you think Linux is the living refutation of that?
Yes, essentially. It's actually a slightly complicated business because of Linux's background and the fact that it's not just one thing. It's been developed on a different basis. But yes, and I think Microsoft actually came to realize that in the 1990s when Linux, having kind of burst on the scene, didn't just disappear, didn't kind of find itself riddled with flaws. When flaws and viruses and so on showed up, Linux proved amazingly efficient at dealing with them, getting rid of them. Yeah. So there's again a famous moment when some internal Microsoft documents were leaked to the open source community. These became known as the Halloween documents. You can look them up online if you want, which revealed the concern within Microsoft's higher echelons when it was realized that Linux wasn't a flash in the pan and that there really was an alternative model for how to proceed here that was viable and in some ways more viable than proprietary models. So I think the short answer to that is yes.
Thank you for coming. Really appreciated it. Very, very informative book.
Oh, thank you very much.
Thank you.
Thanks.
To the audience, be with us again next time for the next installment of Books of Our Time.